Good afternoon. My name is Kate Shank, and I'm the Deputy Director of Legal Aid Chicago. Welcome to Legal Aid Chicago's final session of our series, The Emerging Legal Crisis Facing Chicago's Black and Brown Communities. Our session today will focus on barriers to employment. It's now my pleasure to introduce our hosts for today. They're from Jenner & Block. It's Ann Mitchell and Megan Petzel.
Hi everyone, I'm Megan Petzel. On behalf of all my partners at Jenner & Block, welcome to this final session of the amazing webinar series that Legal Aid Chicago has put on for us this summer. We're proud to sponsor today's discussion on barriers to employment as part of our long-standing support of Legal Aid Chicago. We feel aligned with Legal Aid Chicago's wonderful staff because the Legal Aid Chicago lawyers and Jenner attorneys share the deeply rooted belief that we have a professional and moral responsibility to promote equity in the justice system for under-resourced people. In fact, this year, Jenner was recognized by the American Lawyer for the 4th consecutive year as having the #1 pro bono program in the country. And we think Legal Aid Chicago is the #1 legal aid organization in the country. So thank you to Legal Aid Chicago for everything you do to help make sure everyone in our city has the opportunity for their voices to be heard in our legal system. We look forward to working with you and supporting your efforts for years to come. And now let me turn it over to Ann Mitchell to introduce today's program.
Thank you so much, Megan. Good afternoon. It's my pleasure to introduce the panelists for today's important discussion. Mark Mitchell, who's the Re-Entry Program Manager with Teamwork Inglewood, Regina Hernandez, who is a staff attorney in the Volunteer Services Unit of Legal Aid Chicago, and James Brady, who's a supervisory attorney in the Consumer Practice Group of Legal Aid Chicago. They will be discussing barriers to employment, the emerging legal crisis facing Chicago's Black and Brown communities, and I'd like to turn it over to Mark as the first speaker. Thank you.
Hi, good afternoon. My name is Mark Mitchell. I am the Director of Reentry Services for Teamwork Inglewood. I am not related to Ann Mitchell. My path to this position is a little different now. Every time I would come home from prison, everyone would be happy to see me. They'd say, Mark's home, and they'd be glad for 1 week. The next week, they'd say, Mark's home, and no one was happy. Because they knew, like I knew, that I was going back. Right? And it always happened. I'd try to get a job. I'd go to these institutions that would do these job readiness programs, and I'd get frustrated because I couldn't get a job. I'd be I'd come home, and the family would be waiting on me to help, and here I am going to a job readiness program for months and weeks, and it would get frustrating. And when I did get a job, it was like way out in Schaumburg somewhere, where it would take me 2.5 hours to get to work, and I would get frustrated, and sooner or later that job would pull my background, and I'd lose that job. And every time I got frustrated, I'd say these two words that would turn me into a schizophrenic nut. I'd say F it. Once I said F it, it was not whether I was going back, it was when I was going back. And for some reason, this last time I said F it again. And as I was out there, I was looking for anything, any kind of way. I was like a nut. And I ran into this guy on the street, and his name was Cold Blooded. Now, Cold Blooded was a stick-up guy. That wasn't my thing, but I just said F it. So I was kind of like interested. I said, wow, Cold Blooded got a suit on. Maybe he's going to rob a bank. I want to see if he needed a driver. Cold Blooded started talking real crazy to me. He talked about changing my life, go back to school. You know, he asked me if I'd gotten my GED. And I did. I got my GED while I was incarcerated. I just got out of a program called ABE. In prison, you have to go to ABE if you don't test well. And I tested, when they tested me upon entrance, I had elementary school scores. So I didn't test well. So they put me in ABE. And once you leave ABE, you go into GED. So my first day in GED class was test day. And the guy came in, he says, okay, take the test. I said, look, I just came out of ABE. I'm not going to pass this test. He said, well, take it for the experience. He passed the test out, then he left the room. I looked down the hall, I didn't see him. I looked up, I didn't see any cameras. I said, this is my kind of test. I asked the guy next to me, I said, what you got on there? He had nothing but his name on. I said, okay, what's the next guy? What you got? He said, where you put your name? I said, I know where to put my name, man. How long you been in GED class? To make a long story short, we had the phones, bro. There was 3 phones outside the classroom. We had 3 phones running for 3 hours. My daughter did all the math. We came back and we shared all the answers with everybody in the room and told everybody that cheating after, don't put the same thing. The guy never came back, don't know what he was going through, so we left the test on his desk. We came back over the weekend, the guy said, look, I have a problem with the test results. We said, what's the problem? He said, y'all all passed with the same score. Can anybody explain that? A guy from California got up. He said, I'll explain it. He said, we eat the same food, wear the same clothes, go to bed at the same time. Why wouldn't we all think alike? So I got this bogus GED. And so my man cold-blooded, he says, look, go up there to the school and register. So I went up there and they told me I had to take the entry exam. I said, entry exam? That don't sound good. They put me in a room by myself and I scored ABE, 8th grade and under on everything but reading comprehension. On reading comprehension, I scored over 12th grade. You know why? I have 13 felony convictions. I've been indicted so much I learned words like aggravating and mitigating, concurrent and consecutive, probable cause. So look, and so I called my man, I was excited. I said, man, cold-blooded, they let me in. He said, you in? I said, yeah, I'm in. He said, what class you got? I said, I got the prerequisites. He said, man, you got the slow class. And he wasn't lying. In slow English, they wrote on the board, Jack ran. What's the verb? What's the noun? Before I could even answer, girl jumped up in the back talking about that depending on what Jack running from. So look, but it's something about, and it's something about, you know, being an ex-offender, you taught to think on your feet. So when they was on sentences, I was on paragraphs. When they got on paragraphs, I was on paper. And I would continue to go through these classes, right? And I remember when I was in my undergrad, and they called me to the office. They said, Mark Mitchell, you wanted at the office. Now, I've never in my life had a good conclusion from Mark Mitchell, you wanted at the office. In high school, they called me to the office. Next thing you know, 15 minutes later, I'm being charged with strong arm robbery. Me and a guy from a different gang, we didn't even know each other, evidently robbed somebody. That was my first juvenile arrest. After I got out of there, I couldn't go back to that school because they wouldn't let me in. So they killed school for me. The one time I had a job, they called me at lunch. They said they want to see you at the office at lunch and bring all the other black guys with you. And I told myself, I've been the senior man. Y'all getting ready to watch me get a promotion. And they were all excited. Yeah, they all got there and the man fired all of us. Get your butt out of here. In the penitentiary, when they come by your cell and say the captain or the lieutenant wants you in the office, you go into the hole. So as soon as they said in school, they want you at the office, I got real scared because I've always had this impending doom concept. Right? So when I got ready to leave the college, I said, I'm out of here. And someone told me to call my mentor. And I called him. He said, man, go see. I said, they got me. He said, what you mean? I said, they got me. He said, what you do? I said, I don't know, but they got me. So I said, okay. He said, go see what they want. And I was reluctant, but I went. When I walked into the door, the woman said, you summa cum laude. I said, you're a damn lie. My name Mark Mitchell. I don't know what summa did, but you're not going to put it on me. So, look, she said, look, she called me an idiot, I think. She said, look, idiot, summa cum laude means you smarter than 95% of the people here. You know, and that shocked me. I didn't know I was smart. And I continued on that path until I looked up, like I said, and I ended up with a first master's. And then I got a second master's. And finally, I worked in the field, setting up halfway houses for employment and education. And I ended up doing Teamwork Inglewood. And when I got there, I never heard of them because they had a rich one, but I hadn't heard of them. So when I got there, I was kind of confused as to what it is they do. And Teamwork Inglewood is contracted by the city to be a referral center. So if an individual comes home, he dials 311, and they say, well, I just got home, and they'll say, okay, we'll call Teamwork Inglewood if you're on the south side. And at that point, we would refer them to other reentry organizations. And those were the same organizations that I was getting out of, I was dealing with 20 years ago, running the same programs that they were running 20 years ago. So in good conscience, I couldn't do that. So they told me to build a program the way I wanted to, without any additional funding, just do what you want. While I was in there, in my master's in criminal justice, I wrote a paper on middle-aged ex-offenders. So you know, and that if a middle-aged ex-offender is employed within 90 days of release, he has a higher work ethic, or just as good a work ethic as the average person. That this work ethic starts to dissipate if unemployment persists beyond this 90-day period. So I said, wow, that made so much sense to me, that if I got a job when I first got home, how it would affect my self-esteem. So I knocked on 200 doors to get one company to open up to us. And that company said, well, send me 8 people. We sent them 8. The next week, they said, send me 8 more. We sent them 8. The next 2 weeks, said 8 and 8. So after a month, they called us in. They had 5 temp agencies there. And they said, Mark, they told the temp agency, your retention numbers in 30 days are 20%. Mark's retention numbers are 80%. So the model held true. And what that did is it opened other doors for us. We've gotten 3, 4 other different plants. We've placed over maybe 1,300 people prior to COVID, the COVID epidemic. And these guys, we got guys there that had never had a job, who are there now, have been there for years, who are full-time employees. We've taken dope dealers off the street and made them supervisors at some plants. We've taken gang leaders, right, and they're now union stewards. And it was great. I mean, this experiment, this model, right, this has been great, you know, and we've done some other things. We looked at the law change in reference to sealing. I'll let someone else explain what that means, but individuals didn't know on the street that that was a possibility. Because the one thing about my sentence is that it never ends. It's a constant. You don't see it, but I do. You know, I went with my wife to rent an apartment about 4 or 5 years ago, and they ran a background. My background's over 20 years old, and they denied me. If I went to Walmart to apply for a job, they would deny me. So getting these barriers to employment, this background, getting, you know, it isn't an impediment. I mean, in an ideal world, we would say, okay, you paid your debt, all bets are off, you've done great. But that doesn't happen. It's a constant. It never goes away. It's always there to remind me that I'm not good enough, that I'm different. And we can't say lives matter and not address this. We can't say that people that we care about, you know, and not address this. It continues to be there. And we've done some things where we say, okay, you know, because a guy would get off his job like me way out in Schaumburg, where he would drive for 2.5 hours to get there. And then 2.5 hours, he would take this day off and then go downtown when he did find about sealing, and he'd run down there. And if he wasn't the first 25 people, then he would miss an opportunity. He didn't know that. He got there at 9. It was too late. He called me. So he'd go back another day. He'd get there at 8:30, and he'd be the first 25, but he didn't have his rap sheet. So he'd have to take off another day. And these cycles continued because there was only seemingly one game in town, but that's different. So we did some things. We elected to pay for rap sheets, you know, because a lot of individuals don't have that money. We pulled rap sheets. We trained interns on how to help individuals do pro se petitions. We got the assistance of the state's attorney, who the petitions that we did present, before we filed them, they reviewed them for objections. The clerk's office opened the door for us and let us bring all our people out, over 100 people in one day. We've done, the chief judge helped us with getting the judge to waive those fees. And we've done that 3 times. And some of those are still in the system over a year, and that's something I don't quite understand. When COVID hit, it changed our operation. So right now it's like we're back at 50%. And it's kind of hard to get more plants to buy in because I can't get in the door. So that's why I'm asking everyone that's listening to kind of act as an employment agent for me. That if you want someone with a model that's been best evidence model that's been tested, that has been proven to increase job retention, then I'm asking you to reach out to me or send me that information, that employer. The only way, to change the lives, to me, of African Americans, because look, 14 to 16,000 individuals come out of the Illinois Department of Correction to the Chicagoland area every year. That's astounding. They go to the same 5 communities where there are no resources. So what do these young guys see when they see a guy come home and he doesn't have a job? He gets up and he does nothing. He has nowhere to go. That tells them, I don't want to be like him. I'm going to get mine now, as they say. So, to change the lives of these individuals, because like I say, it's 93% of the people come out of prison are black, are males, right? And the majority of them are African Americans. Right? The majority of the people incarcerated, even though we're 13% of the population, we're 55% of the prison population. We can't say that we're going to change lives and not address this. We have to address this. We have to get individuals to become men among men. Right? So I'm not going to carry on. I think my time is up. And at this point, I'm going to turn this over to Regina Hernandez. Thank you.
Thank you so much, Mark. I sincerely appreciate you sharing such a personal story that I think really contextualizes what we're talking about today. So to everyone, good afternoon. Once again, my name is Regina Hernandez, and it is a pleasure to be with all of you today on behalf of my agency and on behalf of this impactful work that I am so proud to be a part of. Now, when I use the term impactful, I mean this on an incredibly large scale. In Illinois alone, 3.3 million adults alive today have been arrested or convicted of a crime since 1979. Even if you are simply arrested and released without charging, a record is created, and it's a record that does not go away automatically. These records collectively create what we refer to as permanent punishments, the laws, regulations, and restrictions that restrict the rights of people with records beyond their involvement with the criminal legal system. These restrictions that deny people access to fundamental needs, such as housing and employment. In the state of Illinois, there are over 1,000 of these regulations and sanctions that create a system of barriers for those with criminal records, in addition to the already existing stigmas that come with involvement in the criminal legal system. In addition to presenting this data as a way of stressing the importance of relief work and why this really matters, I also like to point this statistic out as a way of clarifying to those who may need our services that you are unfortunately far from alone. There are stigmas that already exist in our society that disproportionately impact Black and Brown communities. When we look at the data with regards to who is being arrested, prosecuted, and incarcerated in Illinois alone, we can see a stark inequity in who this is impacting. And given this, we have to also consider the long-term impact of this on these communities, factoring in those permanent punishments on individuals with record of their involvement in the legal system. Being done with your sentence in the criminal system, just as Mark was explaining, does not necessarily mean that you are done being punished. While laws that restrict formerly incarcerated individuals are supposed to be under this guise of public safety, there is really far more evidence to the contrary, that this just perpetuates an endless cycle of poverty and continued criminal prosecution for primarily Black and Brown people. And this is why legal remedies like expungement and sealing, which we're going to talk about today, are so crucial, and why this is a part of vital racial justice work. So let's clarify the key types of criminal records relief that we're talking about. Expungement is the most effective and permanent way to remove a criminal record. It's a remedy only available for non-convictions that completely destroy, impound, and prevent both public and private entities from ever seeing that record again. Non-convictions, I want to specify, in Illinois, are generally considered to be arrests that results in outcome like dismissals, findings of no guilt, and in successfully completed less serious sentences like supervision. Now, sealing, on the other hand, is the primary form of relief for convictions. This can still be just as effective for many clients as it pertains to employment in particular. However, these will still be records that are generally still available to law enforcement. Now, convictions are more generally understood as findings or admissions of guilt, but it's important to keep in mind that even things like fines for small offenses, like drinking in the public way, are still technically considered convictions in state law. It's also important to keep in mind, as we're making these distinctions, that sealed felony convictions can still be available for those authorized by law to conduct fingerprint-based background checks. And this is really just in some hiding the record from general view, but with exceptions. And that's a really crucial distinction to make, because it can come down to how you were charged and the type of sentence you received that determines what kind of relief you're eligible for. And finally, when expungement and sealing are not an option for that particular person, which can be for a number of different reasons, we look to alternative forms of relief based on that person's individual situation and goals. For instance, let's consider a situation of an individual who is interested in becoming a certified nursing assistant, but has been told that because of a prior old conviction for retail theft, she is disqualified from registering as a CNA, a certified nursing assistant. This client could apply for something called a healthcare waiver through the Illinois Department of Public Health. This would allow her to provide context for her conviction, provide evidence as to why she does not pose a threat to public safety, and if granted, would more directly overcome the exact barrier preventing her from a career in healthcare. And this can also be just more timely than the expungement and sealing process, as we'll discuss a little bit later. The criminal records relief process can be extremely complicated, but I like to break it down into 3 primary steps. First, records research. Obtaining copies of your criminal records and performing additional research to track down necessary information, such as final dispositions, is a crucial part of this process. Just getting a copy of your criminal record alone, which is more commonly referred to as a rap sheet, is unfortunately not always reliable. There is regularly incorrect information, including incorrect or missing disposition information, which is necessary for determining eligibility. So the first step that we always take is to cross-reference everything and make sure that if some record is being attributed to one of our clients, that we find it and that we figure out exactly what the official outcome was. Once we have all of that information we need about a client's record and determine their eligibility based on that research, we can prepare the relief that that client is eligible for, which usually involves a lot of paperwork, very detailed work, and we will go ahead and take that burden away from the client. Once all the paperwork is complete, we file at the appropriate venue, wait for orders granting or denying relief, and appear in court as necessary for each client. I do need to mention that the wait times for the expungement and sealing process widely vary, and it continues to be an issue that we are regularly dealing with. Cook County is comprised of 6 distinct court districts, and each district is different in terms of processing times for expungement and sealing. District 1, for example, is the largest district by far because it encompasses the entire city of Chicago. And as of today, from the day that we file an expungement or sealing petition, it takes over a year to get a response. This is why I am going to stress throughout this presentation how important it is that we explore other practical remedies for clients as we continue to fight this battle that is so important and highlight a lot of these key issues that are really crucial to ongoing advocacy. When someone comes to Legal Aid Chicago for assistance with criminal records relief, our priority is an individualized assessment that is focused on goal advocacy and full representation. We know from experience that the most effective way to help a client obtain their goals and really remove these barriers is to advocate for them every step of the way. For instance, normally, the cost to file a petition to expunge or seal is $120 per petition per district. You have to file a separate petition for each district that you were arrested in. That can really stack up in terms of the cost to an individual. We provide our services at no cost, and because of our status as a civil legal service provider, we file at no cost to the client. We are in a very fortunate position to be able to do this because of our dedicated staff, pro bono attorneys, and our invaluable referral network of partners such as Teamwork Inglewood. And we are able to provide more holistic services for our clients. We want to try to address not just the issue at hand of a client with a criminal record, but we want to evaluate the entire situation and see where else we can help. This might mean a referral internally to one of our housing or employment attorneys. We know and we acknowledge that the current system of criminal records relief is far from perfect and still has a long way to go in terms of its timeliness and its accessibility to our communities. So let's be practical and see what else we can tackle in the meantime. So on a final note, I'd like to highlight 2 client stories of ours to keep some things in mind as you continue to think about this work. First, that even minor offenses that do not result in convictions can pose a life-changing barrier. Kayla is a client of ours with no convictions on her record, but she did have a number of arrests for minor offenses. She also had a job offer that was just out of reach for her. She was told that she would get the job, but only if she cleared her arrest record. Fortunately, we were able to expunge each arrest off of her record, and she was able to secure that new job. Additionally, it's so important to remember that there is often so much that is assumed about a person with a record without knowing anything about their lives and the context for these records. Sharon, for instance, is a client who was also the victim of an extremely abusive relationship. Her criminal record was unfortunately largely the result of a life filled with trauma. Now, out of that abusive relationship, she wanted to move on with her life, improve her own circumstances, and help others with a career in healthcare. Through our advocacy, we were able to clear her entire record and clear a path for her career in healthcare.
Good afternoon. My name is James Brady. I am a supervisory attorney for the Consumer Practice Group for Legal Aid Chicago. The first thing I just want to note is that picture is pre-COVID, and one of the first things I did when we shut down and everybody went remote was I shaved off the beard. So as Mark stated, many people live in communities that are devoid of resources. And so first I wanted to provide some context for that and why that matters when we talk about debt-related barriers to employment. And currently in our country, there exists a wealth gap between whites and people of color. Wealth is the measure of assets that an individual or a family owns, such as a home or retirement accounts, less the debt that they might carry on those pieces of property. And that wealth can be used to provide an education or to put a down payment on a first home or to start a business. It can also provide an important cushion against unexpected shocks, things like a temporary job loss or an unexpected medical bills. And if you have some wealth, you can weather those storms without getting over your head in debt. In 2016, the average wealth of white families in the United States was $919,000, while the average wealth for a black family was only $140,000. So put another way, white family wealth was 7 times greater than black family wealth. Now you might ask, how was this created? Well, this was created through a series of government programs and policies, such as the New Deal, the GI Bills, the Fair Housing Act, that were expressly designed to assist whites in gaining land and home ownership rights, while simultaneously denying people of color the same opportunities. From 1934 to 1962, the government backed over $120 billion in mortgages, but the race-based policies of the FHA meant that fewer than 2% of those loans went to people of color. So at a time when white Americans were gaining access to home ownership and amassing wealth, people of color were denied that opportunity. So this gap in wealth means that our clients, many of our clients, are more likely to live in segregated, lower income neighborhoods that are farther from basic amenities and transportation hubs. It also means that communities of color will have less access to mainstream financial services such as banks and mortgage lenders that enable individuals to save money securely, borrow funds safely, and establish credit, which can lead to building wealth and longer-term financial security. This means that those communities must now rely upon alternative financial services. And unlike mainstream financial services, alternative ones charge much higher fees and interest rates and offer loans that do not help build credit histories. And by their very nature, high-cost loans are more likely to result in default. So because of these systems, many of our clients end up needing to purchase a car because, as Mark stated in his initial presentation, one of his first jobs was way out in Schaumburg, which if someone lives in the city, that is not an easy transportation route to cover to get to work. And because of where people live, they end up using one of these alternative financing services. And when purchasing a car, this means using what is called a buy here, pay here dealer, which is basically a car dealer that sells the car and accepts the payments from the consumer. There is no bank or traditional financing involved. But our clients face several issues when buying a car from one of these dealers. We frequently see inflated sales prices. So these dealers buy these cars at dealer-only wholesale auctions at usually below market value prices. And then when they sell the car to our clients, the down payment usually represents the actual value of the car. Any subsequent payments made by the consumer, for example, on a monthly basis, just line the profit for that dealer. We will see misrepresentations or omissions of a car's condition. So you'll see a car that has been previously totaled, sold on a lot, and the consumer doesn't find out until much later that this car was actually totaled and really shouldn't be on the road. You'll see high interest rates, 25% or higher, not the 1 to 5% financing that you might see advertised on television. We'll see lack of required documents, such as a truthful lending statement, which anytime that you obtain credit, you should get that statement. It is the document that has all the boxes at the top. That statement is intended to inform consumers of their true cost of credit. We'll also see outright fraudulent scams, such as a yo-yo scam. And this is exactly what it sounds like. This occurs when a car buyer who finances the car through the dealer believes that the financing is final when they leave. However, the dealer calls them back a day or 2 days later and says, oh, we're sorry, that deal didn't exactly go through. You need to bring the car back and sign some new papers for us. And the consumer thinks they cannot get out of the deal because they already took possession of the car, and is then pressured into signing a new financing contract with higher interest rates or other less favorable terms. So what can we do? Well, we sue them, basically. We will bring affirmative actions against these dealers who abuse our clients' rights. We will use the various consumer protection statutes that exist, such as the Illinois Consumer Fraud Act, which will allow us to go after a car dealer for misrepresentations or omissions of what's called material fact. That statute will allow us to obtain actual and punitive damages as well as attorney's fees. We will also use the Truth in Lending Act, which is a federal statute. That statute allows us to obtain statutory damages, attorney's fees, and also provides the basis for us to get into federal court. So one client, Carol, she bought a car using her entire 2019 tax refund as a down payment of $3,500. This turned out to be the actual market value of the car. The dealer failed to give her a truth in lending statement and misrepresented the frequency of the remaining payments. And when she missed one of those misrepresented payments, the dealer repossessed the car and refused to return it. Shortly after filing our complaint in federal court, the dealer settled with Carol under terms where she received all of the money that she had paid for the car, plus repairs that she had made and some lost wages as well. The second area of debt-related barriers to employment is in the city's enforcement of parking tickets. Some of this has been widely reported in the news, but it has definitely been widely reported that the city issues more tickets in non-white neighborhoods than in white neighborhoods. And just last week, the Chicago Tribune reported that of the $35,000 in parking tickets issued during the current pandemic, outside of the downtown areas, the zip codes most often ticketed were in low-income neighborhoods. And parking ticket debt has been increasingly recognized as resulting not from a disregard for lawful conduct, but a product of poverty itself, and one that disproportionately impacts people of color. Basically, the fines associated with these tickets are so high that people cannot afford to pay them. So what I'd like you to do here, if you can, is to follow along with the boxes on the right here as I kind of go through some of these. So the city can impound a car for just 3 unpaid tickets. Each ticket, each expired meter ticket, for example, carries an initial fine of $50. So that results in our first box of $150. That amount doubles in 25 days if unpaid. And if that amount is not paid, then the city can boot the car and tow it, which adds another $250 to that debt. The city also then charges fees for each day that the car is impounded, which would result in an additional $560 over 21 days. So this brings the total amount necessary for the owner to get their car back from the city to $1,200, over $1,200. So what was initially a fine of $150 for 3 tickets can very quickly become a debt of almost 10 times the original fines. And for many of our clients who are working at or just above the minimum wage, this amount can be impossible for them to pay. If that $1,200 is not paid within 21 days of the city impounding the car, the city can dispose of it. And notice I did not say sell, because the city doesn't really sell these cars. It doesn't obtain much, if any, value for these cars. It gives them to its private contractor for scrap value. And the city does not even check a vehicle's condition before selling it for scrap. And to make matters worse, the city doesn't even credit the owner with the small amount it receives when it gives the car to the city's private contractor. So in our example on the right, if this car owner was unable to pay that $1,200, regardless of the value of the car, the city can scrap it, and that person is still left with that $1,200 debt owed to the city. Just in terms of numbers, in 2017, the city impounded over 20,000 cars because of unpaid tickets and disposed of over 8,000 of those cars. A loss of a car can mean that one of our clients will not be able to get to work on time, or they could be in a job where a car is required. And if they lose that job, the loss of that job can severely impact their already tenuous financial situation. So what can we do here? Well, we can file a bankruptcy for these clients. In this situation, we need to use a Chapter 13 bankruptcy because of the nature of parking tickets. So there are two types of personal bankruptcy. Chapter 7, which does not require repayment of your debt, and Chapter 13, which is more commonly referred to as a reorganization, where the debtor proposes a plan that is approved by the court to repay some of all their debts. So parking tickets cannot be discharged or wiped out in a Chapter 7, but they can be wiped out in a Chapter 13 as long as the debtor finishes their plan. And so we are able to file a bankruptcy. The city must return the car to the owner upon the filing. The city is not allowed to ask for a down payment or any type of deposit. Also, in certain cases, one advantage of a Chapter 13 is that we can cram down, it's what we call cramming down, a car loan to the value of the car, meaning that regardless of what's owed on the balance of the car contract, in some situations we can actually pay, far less than what the contract calls for, and the owner retains the car at the end of the bankruptcy. So in this case, Mona's car was impounded by the city. She used her car to drive her kids to 2 different schools and then to go to work as a substitute teacher, which meant that she never really knew where she was going to work until usually the morning or kind of on Sunday for Monday, which district she was going to have to work in. If she had to take a bus, her trips would take over 2 hours to get to those different destinations. Once they impounded the car, the city refused to return it to her without full payment of her entire parking ticket debt. So we filed a Chapter 13 bankruptcy, we filed a complaint against the city, and then also negotiated a plan with her auto lender where she would only pay half of the remaining loan balance, which represented the true value of the car at that time, in order for her to retain the car. After some litigation, the city agreed to return the car without any payments and to accept a payment of only 2% of her total ticket debt. And then that debt would be wiped out at the end of the bankruptcy plan. So for many of our clients, owning a car is a necessity so that they can either gain employment or keep employment. But needing a car can present some real thorny debt-related issues that can then inhibit their ability to work. And through our litigation, Legal Aid Chicago can help overcome some of those barriers. So now I'd like to turn it over to Melissa, who is the director of our volunteer services unit. Thank you.
Great, thank you so much, Jim, and especially during this time when so many people are facing employment challenges, combined with the increased attention on systemic racism in so many institutions, this discussion and this work are so critically important. And I'm hoping that many of you are thinking about ways that you can help change these systems alongside us. Just last year, as you can see, many volunteers did exactly that. The type of work that Legal Aid Chicago does and the volunteer projects that we offer really focus on dismantling systems brick by brick. And as you can see here, client by client. Volunteers made a difference in the lives of over 1,000 adults and 375 children in 2019 alone. At Legal Aid Chicago, we have over 20 different volunteer opportunities across the agency. And over the past 8 weeks, I have highlighted several of the ways to get involved in our work across different subject matters, We offer a wide variety of opportunities to serve our clients and help us meet their needs. Regina highlighted the very important work that she is leading on criminal records relief. The client demand in this area is significant, and the only way for us to meet this demand is to utilize volunteer attorneys. Attorneys can assist in the preparation of petitions for expungement and sealing. Legal Aid Chicago does all of the eligibility determination and the court filing. You can assist by completing documents and counseling the client briefly and helping them understand the process. We offer training that is available on demand, and these are short-term, paperwork-based engagements, but I assure you that the impact is substantial, and I believe the rewards are significant. You can find more information about all of our volunteer opportunities on our website, and you are welcome to reach out to me with any questions that you have about any of our opportunities and how you might be able to help. And I will turn it back over to Kate Schenk now.
Thank you, Melissa, and thanks to you, Mark and Regina and Jim, for your really incredible presentations. And special gratitude to Mark for sharing your personal experience and your perspective with everybody today. So this now brings our series to a close. We are just so incredibly proud of the work of our staff and our community partners that have been highlighted through this presentation series, and grateful to the over 1,000 of you who have joined us, 1,000 individual people, and many of you have joined us for multiple of these sessions. It's just been an incredible turnout. Grateful for your work presenting, grateful for your viewership and your engagement with us. Through this series, you've seen how access to justice is just not a given. Chicago's Black and brown communities have been disproportionately affected by civil legal issues that threaten their stability, and COVID has absolutely exacerbated the situation. But we know that here at Legal Aid Chicago, we're up to the task of advocating for those who need help the most. If you have missed any of our previous 7 sessions, again, they'll be available on our YouTube channel tomorrow. So invite you to go or revisit ones that you may have already watched. We've been so glad to share how this work can make such a lasting difference in the lives of our clients and our communities in this critical time. We're grateful for you for taking part in this series. This isn't the end though. Our work for equal justice forges on, and we hope that you will be able to continue to work alongside us in our mission and take advantage of all the opportunities that Melissa has presented throughout these 8 sessions. In a moment, we're going to start the Q&A portion. The panelists are going to remain on to answer your questions, which you should type into the Q&A at the bottom of your screen. I know we have some that have already come in, and Melissa, could you please start taking us through them?
Absolutely. Thank you so much, Kate. And so our first question is actually for Mark. You mentioned about the high rate of retention. And so what explains your high retention rate for returning citizens at jobs?
Okay, great. So I guess you could put it like this. The average age in the Illinois Department of Corrections is 35. So they're middle-aged. So we have middle-aged individuals. So let's put it like with COVID. Let's just say this. So individual gets out, and if he's employed within that 90-day period, he's not infected yet. So, and if he gets this job, it's like he knows this is probably the only last job he's going to get. And sometimes it's the first job. So when this individual gets, he knows he has to keep it. He doesn't have anyone to take care of him. More than likely, he's like he burnt all his bridges. So, you know, and people think that an individual in jail thinks about one thing, getting out and doing more crime. No, not at that age. At that age, you're thinking about one thing, you know, simplicity of life. So if we afford this opportunity to him before the streets get him, where he can go to work every day, you know, it makes him continuously do it. And it's the best evidence model. So, and it makes a lot of sense to me. Okay.
Wonderful. Thanks, Mark. Regina, you mentioned a little bit about arrest data. And so can you tell us, is a county required to keep track on percentages of arrests by race? And is this a number that the public could find and research?
Oh, yes, actually, this is something that has been codified within the main statute that really regulates expungement and sealing in general, which is the Criminal Identification Act. And at each stage of involvement in the criminal legal system, so at the point of arrest, at the point of the Department of Corrections, a good faith effort has to be made by these entities to collect data on race and ethnicity. And generally, this information should be available to the public, and it's available through multiple different ways. The most reliable way and the most consistent place that I have seen it has been through the state's attorney's office. And actually, on the state's attorney's website, Kim Fox has actually done an excellent job of really summarizing all of this data, including disposition information and sentencing information, along with race, with graphics and all sorts of charts and data for the public to view that's readily accessible and pretty consistently up to date. So it is something that is maintained and accessible.
Thanks. All right, Jim, a question for you. Can a prior or recent bankruptcy become a barrier to employment?
I had to unmute myself, sorry. Yes, I think it can. You know, we see that stuff sometimes with prior bankruptcies, with credit history, and sometimes it depends on if the job, you know, requires handling money or financial stuff like that. We do see employers running background checks. Legal Aid Chicago has not entered that kind of sphere of litigation in terms of the use of those reports, mostly because there is a pretty active plaintiff bar in the city that does those cases, that does a lot of those cases. But you know, bankruptcy can kind of creep up in a lot of different ways. The discharge does stay on your report for several years. I want to say it's 7 years after the discharge that it's going to appear on your credit report. So it can affect things in a lot of different ways. What we usually counsel clients, though, is that, you know, the bankruptcy is a last resort. And if you already have a lot of kind of bad things happen to you financially, default on credit cards, you know, usually clients don't have a single default. It's usually a loss of a job, and there's lots of things that happen. So we try to use the bankruptcy strategically to preserve assets, whether it's a home or wages or something like that.
Thanks, Jim. So Regina, you mentioned that one of the first steps that you take is researching a client's record. And so how do you handle and how do you do the research of inaccuracy on a rap sheet?
That's a great question and a core part of my job. So typically when a client first comes to us, I ask for two things. That is a local law enforcement rap sheet, which is typically for us, the CPD, the Chicago Police Department rap sheet, and an Illinois statewide police report, both that can be obtained from Chicago Police Department headquarters for $16. It is required that you get fingerprinted to obtain these records. And this is why this is just the most direct place to go. Then once I have both copies of these records and cross-reference those, then I cross-reference both of those copies with the clerk system, which is ultimately, that's the final authority in terms of the official court record of any subsequent cases that were filed in relation to those arrests. So I try to take everything into account, try to match up approximations of arrest dates with what's appearing in the clerk system, and try to really fit the puzzle pieces together as to what makes the most sense, because there's just very inconsistent data available, because this is information that's essentially passing through a game of telephone, and it's passing through various entities. And ultimately, the court record is what we really go to as the final say, in particular when it comes to the most crucial piece of information, which is the final outcome, because that's what I really need to know for the purposes of determining eligibility.
Great, wonderful. And so, Regina, can you answer this one as well? And the question is, to make sure that I understand, you can expunge records of an arrest as an adult? And what about if you went to court and received a not guilty?
So one of the very first things that I learned that was incredibly shocking when I very first back in the day started this work was that it does not matter if you were released without charging or you were found not guilty or if the state decided not to further prosecute you, that record does not go away automatically. And you have to think about every place that this record exists. It's not only at the point of arrest with the local arresting authority. So if you think about it, it's not just that record with the Chicago Police Department. If charges were filed, that then goes into the clerk system as well. And even if it's dismissed or there's no probable cause, that record still exists. And there is not an automatic process for getting rid of each instance of this record appearing. So yes, as an adult at any age, actually, you can apply to get your record expunged. We do adult and juvenile arrests at Legal Aid Chicago. And this is often used as juvenile expungement, adult expungement, but it's really a distinction in the records and the age of arrest, not in the age that you currently are. So juvenile records are records that occurred typically when you were under the age of 18, and adult records are typically when you were charged as an adult when you were over the age of 18, or when you were a minor and charged as an adult. So there are some complexities as to exactly what qualifies, and the process is a little bit different with juvenile records than it is with adult records. But yes, come to me if you have questions, but you absolutely can and should expunge arrests even if it resulted in dismissals.
Great. And Mark, this is a question for you and hopefully one that you're happy to answer, which is, during the pandemic, is there anything we can do to support Teamwork Inglewood other than donate money?
Yes, we like money, but no. As I stated, if you can act as an employment developer for me, if you know someone that's looking for a job or looking to hire someone, rather, talk to them about what we do, about our retention numbers. I mean, retention is the thing for a lot of people. They want to invest in someone. We have a plant called Skyline Design, which does glass, design of glass. And it was someone referred me, by just hearing me talk, they had them call me. And we've had a great relationship with them in the last 7, 8 months. We've had like 10 people get employed there. So yeah, kind of act as my job developer and give me a call or email. Email is mmitchell@teamworkinglewood.org. All right.
Wonderful. Thanks, Mark. And Jim, this is a question for you. You mentioned Mona. And so the question is, how long did it take to litigate regarding Mona's car? And are there guidelines to litigate the situation pro se or self-represented?
Yeah, so that when that case started, the city had changed its policies. So previous to that case, the city had been releasing cars when someone had filed a bankruptcy, and then the city decided, we're not doing that anymore. We're gonna hold on to the cars and fight the process in the bankruptcy court. So this kind of happened citywide. There were a number of cases that all kind of popped up at the same time. The litigation in that case took about 6 to 8 weeks until we got the resolution and we got the car back a little bit sooner than that, because we had a judge who saw our side and said, give him the car back under the existing bankruptcy law and case law. And then it took a little bit longer to resolve the debt issues. There were 4 or 5 cases that all were being decided by the various bankruptcy judges at the same time. One of them, which is In re Fulton, ended up going to the 7th Circuit. Legal Aid Chicago filed an amicus brief in that matter, and the debtors won. So we won there, and it is now up on appeal to the U.S. Supreme Court, and was supposed to have been heard. I don't think it's been argued yet. I think there were some COVID-related issues. In terms of pro se avenues, I mean, debtors can file bankruptcies pro ses, but Chapter 13s are complicated, and they get more complicated as time goes by. That litigation required not just the filing of all of the bankruptcy papers, which is, 50, 60 pages of documents, but also we had to file what's called an adversary complaint, which is basically a new lawsuit against the city within the confines of the bankruptcy. And then we had to proceed to litigate that. So it can be complicated. I think, though, now with the decision from the Seventh Circuit, it should not be as complicated to get the car back. But it can be complicated for people to represent themselves in bankruptcy.
Great. And Jim, this is a sort of a related question, but along the same vein. So has Legal Aid Chicago considered suing the city of Chicago for the egregious practices of salvaging a parking ticket owner's car without crediting the owner with the value of the car beyond the fines due?
Well, we've thought about it. I can't say that we, beyond just thinking about it, part of the problem is that there is a statutory construct there. There's a law that allows the city to kind of to take the car and then to kind of dispose of it. I believe there has been some litigation about that value kind of being a taking by the state. And I don't have that case law in front of me, but if recollection serves me right, our side lost that battle. But that doesn't mean that at some point, if it continues, that we couldn't revisit that. But right now, we're not necessarily in a position that we're looking to do that.
Great. Regina and Mark, this is kind of a question that either of you could address. And the question is there any chance that the Cook County Court Clerk or the Cook County Court will improve on the 12 months it usually takes before an expungement court hearing is scheduled in District 1?
Probably a Regina question. I would say no. I mean, we're trying to get them to improve. Probably the best thing is to sue the clerk's office to, 25 people a day. And you have literally 700,000 people with criminal records in the Chicagoland area, and you got 25 people a day or 40 people a day at max that you're addressing. So, the courts and the clerk's office needs to, in actuality, do something better. Regina, what would you say?
I think that, my cynicism would probably agree with you and my experience. What I do know is that because this is an issue that we regularly deal with, I know for a fact that there are plenty of advocates who are actively aware of the situation, including representatives from the state's attorney's office. And it's something that is going to continue to build as an issue as the expansion of relief is more readily available, because this will only increase volume and it's just going to continue piling up and creating a further backlog. So at some point, something has to give. I think that there are resources that should be dedicated to helping to address this. But I do think that eventually a change will come, but it's not going to be due to anything just kind of happening automatically. It's going to be due to people like us, advocates, and through just your average everyday citizen just bringing up this issue over and over again and making sure that it's something that is really highlighted as a part of the problem with this process. And people are in talks about it, and we're currently trying to deal with that along with what's going on with the current pandemic. And I am hopeful, and I try to count the small victories that we have as we file in different districts. And all I can do is keep pushing, and I can be very pushy. So we're going to keep fighting this. and eventually something will have to give.
And, you know, in another vein, I believe the statute says, if I'm correct, that there's 60 days to object to this petition. So in theory, if there's no objection in 60 days, in theory, it should be presented soon thereafter. Am I correct again, Regina?
Well, there is some technical issues with that as it pertains to 60 days given notice, and it's about how quickly are these entities that we're giving notice to actually receiving the notice, because it's 60 days to object once they actually receive notice of that petition, and we are not sure exactly when they are receiving that notice at this point. So there's a lot of different things in the air right now that we are really trying to pinpoint, because this has to pass through so many hands. And there is still a lot to be done and a lot of questions that we have as well. And we do this work every day and we have questions every day. So trust me, I am just as frustrated, Mark, but we're fighting this.
Great. And Regina, would you mind clarifying sort of when a court appearance is required? It's a question that we had for an expungement or sealing, and when it might not be.
Sure. So each of the 6 districts in Cook County has their own requirements and procedures as it pertains to court dates. For some districts, you automatically get a court date just as a matter of process. It doesn't matter if there's an objection or not. You just get a court date automatically when you file. For other districts, like District 1, you would only get a court date if there is an objection. And an objection can be made by the state's attorney's office, the Illinois State Police, the local arresting authority, or counsel for the municipality. So the lawyers for the city of Chicago. So if we receive an objection in District 1, for instance, we should be getting a notice of a court date to appear to try to overcome that objection. But by and large, as this has expanded as a form of relief and the volume has increased, it did shift from a client needing to appear regularly for court dates, and we're seeing more of a shift of only appear when necessary. But again, it varies district by district.
Great, thank you. And Jim, this is a question for you. You spoke a little bit about the abuses by non-traditional lenders, and could you speak a little bit to some of the abuses that are occurring from traditional lenders?
Sure. Before I do that, I just want to note that, and thanks to Colsum, who is on staff at Legal Aid Chicago, she sent us a link in our chat that there actually, there was a federal case regarding the unconstitutionality of the taking of the cars that actually was decided in the consumer's favor. This was just decided in February of this year. And so that story should be easily found. I can't figure out how to put it in a link to.
It's okay. It's okay. Jim Contessa took care of it for you.
Great.
Thank you.
Thank you very much. So that it's a real brief story just on the issue, and I'll have to do a little bit more research and see what the posture of that case is now. But in terms of the other question, I mean, we do look at traditional lenders too, like regular banks. One thing with purchases of cars, though, is we don't see as many abuses with those traditional lenders in the purchase of cars. We do still see problems with those lenders with, servicing of mortgages, origination of mortgages, other types of credit. But with the purchases of cars, we tend to see the abuses more with these non-traditional lenders.
Great. Regina, the question is it now not legal to screen backgrounds and deny housing in Illinois?
Unfortunately, it is still legal to be able to screen backgrounds for the purposes of housing. And further, it's important to keep in mind that with adult records in particular, this is all publicly available information. So even without a necessarily formal background check, this is information that you could pretty easily find. Now, as it pertains to housing in particular, a landlord can reject a rental application based on a conviction, but only from the past 3 years. And they have to also consider all relevant factors, such as the conduct that led to the conviction and the sentence and the severity of the offense. And they have to also consider conduct after that conviction. So if an alternative form of relief was sought out, like a certificate of good conduct, that should be factored in as well. However, practically speaking, how that really plays out in terms of determining whether or not that landlord will actually give that tenant with a conviction housing, it's very difficult to really make that call when it's a landlord's individual decision, but at least nothing past the past 3 years can be considered.
Yeah,
Great.
Melissa, I would
Yeah,
just add that. So we do some work in that context with the Fair Credit Reporting Act. The Consumer Practice Group, along with our Housing Practice Group, has done cases that involve subsidized tenancies, so either public housing or like a voucher, a housing choice voucher or something like that, where the CHA, for example, the Chicago Housing Authority, has contracted out with a private background check company to do these checks. We see a lot of false positives because the reports, they're not, they don't have somebody going to a courthouse and checking to make sure, kind of what Regina was just talking about, that somebody was arrested and charges were filed, but then nothing ever happened with them, right? So a case that I did about 1.5 years ago, we had a veteran who had a voucher and was trying to get into housing, and he, a false positive that there was a conviction in Georgia for arson, which would have been a felony and a safety issue. He had never been to Georgia in his life. And so we were able to prove that. We eventually settled with that reporting agency for, a sum of money. But we will look at those cases and take those cases.
great. Thanks, Jim. So Mark, I'm hoping that you can close us up and answer this sort of final question, which is a follow-up to the first one we answered, which is you contrasted your retention rate to the rate of other groups. And are you saying it's simply the age of those whom you work with that's the main factor in your retention rate, or are there other things that you and your staff are doing that are important to this record of success?
I'm contributing to the age. That's what the best evidence stated, that if middle-aged ex-offenders employed in a time frame. But there's some things that we do. We don't do a long job readiness thing, but we do address some things like time management, workplace ethics, just different things that we have learned over the last few years that need addressing. Like I say, you can give an individual a job and a decent job, and that he can get to without traveling 2 to 3 hours, and he's grateful for it. So, and just keeping the job retention up requires us to help him with transportation. Since a lot of people, we found out in our first year, lost their job during the first month because they didn't have bus cards. And we're not funded bus cards. So, we found different ways to try to get them a bus card, just so they can go there till they get paid. Sometimes they don't get paid for 3 weeks. So, and actually, it's more based on the best evidence than what I would say we do. I would say it's just the model. I'd love to take credit for it, but it's the model.
Thank you.
Thank you, Mark. And thank you again to everyone who has joined us for this series, our staff experts, our community partners, and our sponsors. The generosity of the sponsors and our other supporters really helps to make equal justice a reality. So we're grateful to all of you for working for justice, for supporting justice, and learning about what we do and how you can get involved. We invite you to stay connected with us through our website and social media. And thank you for your time again today throughout the series. Enjoy the rest of your day.